Thanks. And do I, to kill the audio, do I push this green button here? Will that make? Is that Chris?
Yes.
Hey, how you doing?
Very good. You're loud and clear.
Terrific. Thanks for the opportunity to do this. This should be a lot of fun.
Yes, I thank you. I think it will be quite good, and I think you'll be happy with the talent of the teams. I see Christina has just joined us as well. She will be co-arbitrating with you, together with John Nyanje, who's 2016 FDI Moot alum, did his LLM last year in Geneva, and has been working at La Live since then. So I think we've got a very good panel today.
Terrific.
Hugh, do you want to preside?
I would defer to my distinguished colleagues as to whether they have any preferences.
Christina?
I completely support Hugh's candidacy for the president of the tribunal.
Well, you could let John preside when he joins, but I'm always tempted to encourage the first person in the room to take on that role.
Perhaps we can at least ask John in case he does have it.
Ask him when he gets here. We're not really under any time pressure. There's no other hearing to follow in this room, at least not until tomorrow. So you can really go over if you want.
And Chris,
Also,
sorry, please go ahead.
No, I was going to say, I just wanted to let you know that I'm recording this, and I'm also live streaming it. So if you have any objection to either of those things, let me know.
No, I don't think I might.
Okay.
In terms of time recording and timekeeping, is that something that will fall to you or to one of us?
I can keep an eye on that. Just so you know, generally, the teams have 40 minutes each, no advocate to speak less than 15 minutes or more than 25. And in that 40 minutes is included any time that they reserve for rebuttal or surrebuttal, up to 5 minutes. Okay, and I'll keep an eye on that as well. If they signpost their arguments for you, saying, I'm going to speak for 13 minutes and my colleague's going to speak for 16 minutes or something like that, that's really up to them. That's part of their time management task, is to see how they allocate that time. You just have to worry, or I just have to worry about the competition guidelines of the minimum 15, maximum 25, and max 5 minutes of rebuttal within that.
But it sounds like we don't need to invite the teams to allocate time at the outset, that they would do that themselves.
No, you don't need to invite them to do that. I think usually they do because they consider it useful road mapping for the tribunal of what they're planning to do. But we will just give them a warning if someone's approaching the 25-minute mark, basically.
With these questions, I'm probably dating myself a little bit, but it's been so long since I participated.
Well, that's a good thing, isn't it? Yeah, now it's worked quite well actually. These online hearings. I'm hopefully not jinxing it now for today or tomorrow, but I was quite pleased that it worked as well as it did. Let me just see if I have anything from John or Socrates. I've just asked one of the standby, or I've asked John by email if he is in fact joining us now, and I've also asked one of the standby arbitrators to sign in case he doesn't, and just perhaps give him a few more minutes to arrive.
Sounds good. Thanks for the update.
Actually, I thought we could also use this time for some pre-hearing niceties. Perhaps that the teams can introduce themselves to the arbitrators and vice versa briefly. Team Gilani.
Greetings, everyone.
Hello. While we're waiting for the third arbitrator to join, who I think is already familiar with the teams, would you like to introduce yourselves briefly to the tribunal?
It's okay. This is Tim Jilani. I am Mushiri, first counsel. Beside me is Najoli, the second counsel. We are pleased to be here. Thank you.
Team Chagla, would you also like to introduce yourself to the tribunal?
Hi, my name is Cindy Renis, and this next to me is Nashipai Chebet Langat, and we represent the respondents.
Thank you. Thank you. I'm going to let Hugh and Christina introduce themselves briefly. I'm just going to point out that Hugh's firm has contributed a significant amount to the Velde Fund that's earmarked for the winners of the All Africa Regional. That's Three Crowns LLP, which I think you all are probably have heard of before at least, but I'll let Hugh introduce himself now.
Thanks very much, Chris. We were delighted to contribute. My name is Hugh Carlson. I'm the managing director of Three Crowns, and as my accent probably betrays, I'm based in the firm's DC office. I also happen to be an alum of this excellent moot.
Christina, we couldn't hear you. Could you say that again, please?
Can you hear me now? Sorry.
Yes.
Okay, something was wrong with my mic, sorry about that. My name is Christina Klikova. I'm an associate at White & Case Miami, working on investment arbitration cases.
So we will probably see you in Miami in a couple of months.
Yes.
Good chance of that. Did you do the dispute resolution program at the University of Miami?
Yes, I did the LLM in arbitration.
Okay. Where are you originally from?
Ukraine.
Ukraine, okay. So very international. Thank you.
Ahora, sí, Preliminaries.
Hugh.
I assume that means that I'll be sitting in the chair seat.
I think that's what that means. The only thing I was going to ask you now is I know that Agustin Sanz had expressed some interest in this hearing as well. Do you think he's available short notice? The reason I say that is because Zacharias has done a couple of hearings already. So Agustin would be fresh eyes and ears.
He may be. He is in Buenos Aires, and I am not. And so I'm unable to just tap on his door, unfortunately.
Got you.
I'm happy to give him a call if that would be at all useful, though.
Do you think that's a good idea or not? I mean,
I'm more than happy to. If it's all
give
right,
it
though,
a try. See if he can, and I'll send him an email as well, just in case he's not checking his email regularly. And because it would just be fresh eyes.
Of course, if it suits the plenary, I'll just be back in about 3 minutes. Then, okay?
Okay, thank you. Zacharias? Hi, Zacharias. Hi. I can't hear you at the moment. What I've asked Hugh Carlson to see if one of his partners had said he was interested in sitting in one of the hearings as well. And I've asked Hugh to check if he's actually available right now, because I think you've seen these teams before, haven't you, Zacharias? Or at least one of them. Zacharias? I can't hear you.
What about now?
Now I can hear you. Yes.
You can't hear me?
Yes. Yeah. Anyway, we'll give Hugh a couple of minutes to talk with Agustin to see whether he wants to do that or not, and otherwise we'll start in the composition that we have now. While we're waiting, let me just post the live stream link down there in the chat for the teams in case they want to share it with their colleagues and friends. Okay? It's also been shared on I think, the FDI Moot Facebook group and pages and things like that as well. I just have to remember to start it. I think I did jinx myself. This is somewhat disconcerting. I want to have more arbitrators and not fewer, but I seem to be losing them.
Hello, can you hear me?
Yes, I can.
So I apologize for the delay. Augustine notes that he has a call coming up at 10 a.m. Eastern, which he's happy to reschedule if we're unable to find an alternative candidate.
Let's see. Yes, I can. Actually.
Sorry, Chris, you broke up there a little bit. Was that we should proceed with letting Augustine know to join us?
Yeah, please ask Augustine to join us if he can, because we've lost Zacharias as well on the connection. That would be great if he could do that.
I'll write him right now.
Yes, please. Please. Sorry about that. I was getting the live stream audio as well. So I had our conversation twice with a delay of a couple of seconds, and it was throwing me off.
I've just written him now, so with any luck, he'll be joining us shortly.
Thanks. Very much appreciated. I don't know what happened with John, and Zacharias was on standby, but as I said, he's seen, I think, at least one of these teams previously. So.
Understood. That the council will have two arbitrators from the same firm may invite a challenge, so we'll have to be prepared for that.
I can tell you, I can give you a reason why that's okay, but I don't want to do it yet. I can do it when the hearing is finished, and it will actually seem fitting to you.
Terrific.
I've just adjusted that separate hearing private room for the arbitrators to confer on the scoring to be available a little bit later than I originally planned.
Hey, Chris.
Yeah.
All right, that was Augustine. He just flagged that he's run up against some internal headwinds and trying to reschedule given the unavailability of others. And so he said two things. First, he apologizes, and second, he would be available in about 90 minutes time if that suits to pick up. That's probably a bit late for everyone, and in fact, I can't make that, but I'm just putting that along.
Why don't we try to proceed without him with two arbitrators, and if there's, I will sit quietly in the background, and if you two are in disagreement, then I'll have the deciding vote. How's that? And I don't think it's too tragic either, and I'll explain that at the end as well. If the teams are all right with that.
We're okay.
You okay with that?
Yes.
Okay. Thank you. Chagna, are you all right with that as well?
Yes, we are.
Thank you very much. So with that, I think we can begin, and I will turn it over to Mr. Carlson, who is our presiding arbitrator today.
Thanks very much, Chris. So we're delighted to commence this arbitration proceeding between Friendslook PLC, Speak Up Media Inc., and Whistler Inc., opposite the Republic of Tyria, in ICSID case number ARB 18155. Before we proceed, just some quick housekeeping queries. First, I'd like to confirm that we have counsel's order here. So what I'll do is just briefly go through my understanding of the arguments as they'll proceed, and I'd be grateful if counsel at the end of that could kindly sign off that this is consistent with their understanding. First, I understand that respondent will submit on the preliminary issues A, B, and C, and that'll be Ms. Langa from Chagla. Is that correct?
Yes, it is.
Thank you. Next, claimant will respond to those preliminary issues, and that'll be Mr. Shiri from Jelani.
Yes.
Very good. Then we have rebuttal and surrebuttal, followed by claimant submitting on substantive issues D and E. And I apologize for any mispronunciations, genuinely, but that'll be Mr. Najoli from Jelani.
Yes.
And then finally, in terms of the substantive pleadings, we'll have respondent responding to the substantive issues, and that will be Ms. Mioma from Chagla.
Yes.
Very good. Very much. Does my distinguished co-arbitrator have anything to ask of counsel before we begin?
I'm fine. Thank you. No questions.
No, thank you.
do counsel have any points that they wish to raise preliminarily before we commence?
We can't hear arbitrator Christina.
Can you hear me now?
No, though we can't hear her well.
You cannot hear me.
No, I think Christina. I
Christina. Okay.
I'm unable to hear Christina. Christina, would you mind speaking into the mic?
Yes. Can you hear me now?
Yes, yes.
Okay. Thank you.
Thank you.
Counsel, any other housekeeping items that you wish to raise?
No.
Very good, then. Any further input from my co-arbitrators, we'd like to invite counsel for Respondent to commence on the preliminary issues.
Okay. Thank you, honorable members of the tribunal, for this chance. My name is Nashipai Langat. Together with me is my co-counsel, Ms. Mioma Cindy. We appear for the respondents in this matter. Our submissions will take 40 minutes. I will take 15 minutes to make our submissions on the preliminary issues, and thereafter, Ms. Cindy will take 20 minutes to make our submissions on the merits of this claim. Thereafter, we'd like to reserve 5 minutes for the SAR rebuttals. If there are no concerns from the tribunal, I'll begin with the first issue, being whether the tribunal should grant the provisional measures sought by the respondent. The respondent submits that these provisional measures should be granted by the tribunal. Article 47 of the International Covenant for Settlement of Investment Disputes, which I shall hereinafter refer to as ICSID, forms the basis of this particular request for provisional measures. Article 47 provides that provisional measures should be granted in order to preserve the rights of any party to a dispute. General ICSID practice and tribunals have defined this to mean that provisional measures should be granted where they are 1, necessary, 2, urgent, and 3, required in order to prevent irreparable harm. I invite the tribunal to turn with me to page 36 of the problem, and in particular paragraph 3, which lists the articles behind which the claimant is. These articles amount to propaganda against the respondent as regards issues currently in dispute before this tribunal today. This misrepresentation of issues by the claimant to the public incites and inflames the violent, volatile social and political situation within the Republic of Tyria. Our citizens continue with this violence the more they're exposed to this propaganda by the claimant, and therefore it is necessary to grant these provisional measures in order to protect human life within Tyria. Secondly, it is urgent that these provisional measures are granted as fast as possible. Members of the tribunal, the longer we stay without granting these provisional measures, the more dire the situation within Tyria becomes. It is therefore prudent that these provisional measures are granted as fast as possible. Thirdly, it is necessary that these provisional measures are granted in order to prevent irreparable harm. I'm sure it is not lost upon the tribunal that once death has occurred, it cannot be reversed. Once these lives are lost as a result of the propaganda by the claimant, then there is no way that these deaths can be reversed, and therefore it is prudent that these provisional measures are granted. Secondly, in addition to that, the publications by the claimant interfere with the procedural.
Can I interrupt you for a moment, counsel? Do I understand you correctly that you are saying the claimant's propaganda is contributing to the civil unrest?
Yes, it is. Yes.
My recollection from the case file was that the claimant's propaganda was more directed at the respondent's international reputation and chances of hosting certain events, and that I don't recall from the case on any link between the propaganda and the civil unrest.
Thank you for that question. I'd like to refer you to our request for provisional measures, and in particular on page 38, paragraph 11, if you turn with me, you'll find that the continuous misuse and misrepresentation of these arguments will further inflame the political and social situation within our republic. And therefore, we seek to protect these rights by stopping the claimants from making these publications.
Counsel, if I may just follow up on my colleague's question to you. Are you supporting an oral assertion with reference to a written assertion in your submissions?
Yes, we are.
Are you able to support either assertion with reference to the factual record?
We are not able to support that with facts. However, if the situation is allowed to continue, then this will become the factual reality. If I may proceed. The publications by the claimants are likely to cause harm to the procedural integrity of the proceedings before this tribunal. That being because by making these publications, especially in the public arena, the claimants will cause this dispute, will cause a misrepresentation of the dispute before this tribunal to the international sphere. I invite the tribunal to turn with me to paragraph 24 of the statement of uncontested facts in page 53. This, where the claimants hired a public relations firm with the aim of expediting the process before this tribunal. This constitutes a clear and imminent threat to the respondent's rights to procedural integrity of the proceedings before this tribunal. Thirdly, our future interests are prejudiced, and in particular, our economic rights. And by this, we mean our rights to host the World Expo 2025. According to our statement of our request for provisional measures in paragraph 7, the claimant refused to stop the aggravation until the respondent withdrew its bid to host the World Expo. This is direct interference with our rights, and we ask that the tribunal grant these provisional measures as fast as possible. Further, we
Counsel, if I may, just a follow-up question to clarify. I didn't quite follow your factual basis for asserting that the procedural integrity of this arbitration has been compromised. Would you kindly point us to where in the record you're drawing support for that assertion?
Okay, page 53 of the statement of the problem, and in particular, paragraph 24 of the statement of uncontested facts, wherein the claimant cited, the Whistler's spokesperson in particular, cited that its reasons for these measures was to expedite bilateral resolution of the dispute. Does that answer your question, Mr. Arbitrator?
I'm not sure that it does. Could you help us understand the link between a desire to expedite the proceeding, which could conceivably just be the natural disposition of claimant's counsel or a representative thereof, and compromise of the procedural integrity of the arbitration?
Okay. I'd like to, in answer to that question, I'd like to refer the tribunal to the pulp mills case, wherein the tribunal therein found that there is no need for imminent threat because the interpretation of Article 41 includes situations where there are where parties resort to extrajudicial coercive measures unrelated to the subject matter in dispute that aggravate a dispute by interfering with the rights of the the resort to unofficial measures referenced in paragraph 24 is indeed a resort to extrajudicial coercive measures by the claimant to solve the dispute before this tribunal.
But counsel, those are related to this dispute, whereas the standard that you just articulated appeared to extend only to issues that are unrelated to the dispute. Is that right?
Yes, it is. I stand guided by the tribunal on that particular fact. If I may conclude, in Quiborax versus Bolivia, the tribunal in its award of provisional measures stated that if measures are intended to protect the procedural integrity of proceedings, then they are urgent by definition. For these reasons, the respondents request that the provisional measures sought be granted. If there are no questions by the tribunal, I'd like to move on to the second aspect of the preliminary issues, which is whether this tribunal has jurisdiction over this dispute despite denunciation of ICSID by the respondent. It is the respondent's submission that this tribunal does not have jurisdiction because of the denunciation of ICSID by the respondent. Article 71 of the ICSID Convention provides for the rights of parties to denounce the ICSID Convention and further states that this denunciation will take effect 6 months after the filing of the notice of denunciation. Further, Article 72 addresses the rights and obligations arising after this denunciation. And in particular, it protects any rights and obligations, including consent, that were in existence before the filing of the notice of denunciation. According to the facts, the respondent denounced the ICSID Convention on 5th January 2018. The claimants accepted the offer to arbitrate through a request for arbitration on 29th June 2018 and was subsequently registered on 16th July 2018. This therefore means that in light of Article 72, by the time of filing of the request of arbitration, the respondent had no such obligations towards the claimants. That is to say, these obligations were not obligations that were contemplated under the protection of Article 72. Further, Article 25 of ICSID, which provides for the irrevocability of consent, only refers to consent that has been perfected. That is, where an offer to arbitrate has been accepted, leading to an agreement to arbitrate, which was not the case in this matter, as at the time of filing of the notice of denunciation. The tribunal in Fabrica versus Venezuela found that it only had jurisdiction if the respondent state had entered into an agreement to arbitrate before the filing of its notice of denunciation. That was not the case in this particular instance, as the notice of denunciation was filed before the acceptance of the offer to arbitrate set out in the bilateral investment treaties. And for that reason, we submit that this tribunal does not have jurisdiction over this dispute by virtue of the denunciation of the ICSID Convention by the respondent. If there are no questions from the tribunal, I'd like to move on to my third issue under preliminary issues, which is whether this tribunal has jurisdiction over the multi-party claims brought by the claimants. The respondents submit that this tribunal does not have jurisdiction over this dispute because it did not consent to multi-party claims. Factually, we are told that one, the claimants are 3 different companies with 3 different modes of operation. I invite the tribunal to turn with me to page 49 of the statement, which constitutes a statement of uncontested facts. In particular, paragraph 7, where we are told that FriendsLook is a platform for adults to share posts. Further, in paragraph 8, we are told that Whistler is a platform for sharing short messages, and lastly, that SpeakUp is a platform for blogs. Secondly, the claimants have different shareholdings. In fact, FriendsLook is a public company, The other two are not. They have only, the three claimants have only minority shareholders. Shareholders in common rather. Expedia, TurboHub, and TurboFin are the three shareholders that the claimants have in common, all of whom cumulatively own less than 10% shares in all three claimants.
Counsel, if I may, just to clarify, could you help the tribunal understand how the shareholding structure of the individual claimants informs the tribunal's determination as to whether multi-party jurisdiction is permissible?
Okay, thank you. The reason I have pointed out the different shareholdings and the different structures of the claimants is in order to show the tribunal that in fact these claimants operate different businesses and do not have enough in common to justify bringing a single claim before this tribunal.
So counsel, to clarify then, is your assertion that there is a threshold, a legal standard that needs to be met in terms of the parties having different issues in common in order for there to be multi-party arbitration?
I ask that you please rephrase your question.
Sure. Counsel, I understand you to be directing the tribunal to the commonality or the lack thereof between the parties. Is that correct?
Yes, yes, I am.
And you would appear to be doing so in order to assert that there is insufficient commonality in order to achieve multi-party jurisdiction. Is that correct?
Yes, it is.
So what is the legal standard for commonality? To where should this tribunal look in order to understand what constitutes sufficient commonality between the parties in order to achieve multi-party jurisdiction?
Thank you. In establishing sufficient commonality, I invite this tribunal to consider of persuasive value findings by different previous tribunals, such as the tribunal in Alemany versus Argentina, which found that in order for claims to be brought together as a multi-party claim, then it must be shown that the claims and the parties are all identical as regards merits. That is, the claims, the parties all have equal standing as regards the state, party to that dispute, and the merits of that particular claim are exactly the same.
And how are the merits as concerns the different parties different in this case?
The merits are different because the bilateral investment treaties forming the basis of the bringing of this claim before this tribunal today are two different bilateral investment treaties. And therefore, they are brought before this tribunal on based on two different laws. And further, they do not provide in any way for the dispute to be brought as a multi-party basis, on a multi-party basis, sorry. And further, laws passed by the respondent, which forms the basis of their claims, further, are all different, are laws that affect the claimants differently based on the fact that the claimants all run different types of businesses. Or they all run different types of businesses. For instance, Friends Look is a platform for adults, Whistler is a platform for short messages, and Speak Up is a platform for blogs.
Counsel, I understood your standard, and please do correct me if this is incorrect, but your standard to assert that identity between the claims was a prerequisite, not identity between the business models. Are there any differences between the claimants' respective claims being advanced?
Yes, there are. I invite the tribunal to look with me at the expert analysis, and you'll find that the amounts that the claimants seek from the respondent as direct damages for the loss of their investments are different amounts. This therefore means they have different claims before this tribunal today against the respondent.
Counsel, just so we can conclude this line of questioning, your position is that in order for there to be multi-party claims, those claimants need to have identical amounts being requested in damages in order to be able to proceed on jurisdiction?
they need to have identical merits before this tribunal today.
Please proceed.
Okay, thank you. Further, our second head of argument under that is that the wording of Article 9 of the Bilateral Investment Treaties does not contemplate a scenario where multi-party claims are brought before a single tribunal. I invite the tribunal to turn with me to page 56, which provides the bilateral investment treaties, and in particular Article 9. And we are told that consent shall be at the request of the national concerned, national being in singular. This therefore means that the respondent has not consented to multi-party claims. In Plama Consortium versus Bulgaria, the tribunal found that state consent must be clear and unambiguous. In this case, the claimants have failed to show clear and unambiguous consent by the respondent to multi-party claims. And indeed, the respondent has not consented to multi-party claims. And for these reasons, we submit that the tribunal does not have jurisdiction to hear and determine this dispute on a multi-party basis. Having dealt with those three issues, I now lay to rest the respondent's case on the preliminary issues.
Thank you, counsel. Do my colleagues have any questions for counsel to respondent?
I would just have a very general question. And why is respondent reluctant to settle these claims in one set of proceedings? Wouldn't that be faster and easier and less costly?
Yes, it would be faster, easier, and less costly, but we also have to consider the fact that these are three different claims. Essentially, the actions that the claimants are bringing before this tribunal of the respondent are different actions and might have different impacts on the three claimants. And therefore, to reduce the risk of one tribunal finding against the respondent, and they're in a way spreading the risk in order to reduce the negative effects of any negative finding by the tribunal.
So respondent is happier to take a big risk on this tribunal than smaller risks on several tribunals.
Yes.
Yes. Okay, thank you.
Any additional questions?
No, thank you.
Very good. Thanks very much to counsel for respondent for the presentation. The tribunal would now like to invite counsel for claimant to address the same preliminary issues.
Thank you, Mr. President. Appearing before you is Samson Mushiri, first counsel for the claimants, that is Friends Look, Whistler, and Speak Up Media in their dispute against the state of Tyrea. Beside me is my co-counsel, Mr. Major Najoli, and together we shall utilize the 40 minutes allocated to us in the following ways. I shall spend the first 15 minutes to address the first three issues. Thereafter, I shall reserve 2 minutes for rebuttals. My co-counsel shall spend the remaining 21 minutes to address this tribunal on issue D and issue E, and thereafter we shall have 2 minutes for rebuttals. If there be any questions on our allocation of time, I'll request that they be given to us at this point. If there are no questions, may I proceed with my submissions? In commencing my submissions to this tribunal today, I shall pose this question. Is a contracting state justified in imposing unlawful measures to the detriment of investors? In submitting on the first issue, the claimants submits that this tribunal should deny the respondent the provisional measures sought. Thereafter, the claimants shall submit that this tribunal does have the jurisdiction to handle this dispute despite the respondent denouncing the exit convention. On the last issue, the claimants shall submit that this tribunal does have jurisdiction to handle this dispute despite it being based on a multi-party basis. On the issue of provisional measures, the claimant does agree with the respondent that this tribunal is empowered to grant provisional measures pursuant to Article 47. However, we would like to bring it to this tribunal's attention that Rule 39 of the arbitration rules does specify that for a party to be granted such measures, they must specify the rights. The following rights have been identified by the respondent. The respondent has first established that the propaganda alleged to be publicized by the claimants shall affect their future interests economically. We'd like to submit to this tribunal that such rights are not valid to guarantee provisional measures. The ICSI tribunal in the case of Mafezini versus Spain established that the rights to be protected by provisional measures need to be existing and present rights, not those in the future. It was further stated in Churchill Manning versus Indonesia that speculative rights or hypothetical rights do not warrant the grant of provisional measures. If I could refer you back, honorable members of this tribunal, to page 38 of the request for provisional measures, specifically in paragraph 7 and 8. In the last sentence of paragraph 7 and further in the contents, the first sentence of paragraph 8, the respondent has quoted that the claimants allegedly threaten its bid for hosting the World Expo 2025. The claimant submits that such an interest is in the future and in its fact not valid to be protected by provisional measures.
Counsel, if I may just clarify, your position is that a provisional measure may not be introduced in order to protect or preserve some future interest. Is that correct?
Yes.
What is counsel's position with regard to the purpose of a provisional measure? Why does it exist, just generally?
Our position is that provisional measures should be intended to preserve the rights of parties to a dispute.
Okay, but if we're looking at a provisional member, it's to protect against some future conduct. Is that right?
Yes.
Okay, so how is it that we can be protecting against future conduct, but not have that future conduct concern a future interest?
Okay, thank you, Mr. Abitata, for that question. Future conduct may be protected or limited where it affects valid rights that warrant provisional measures. The claimant's submission is that economic interests, especially those in the future, do not warrant such protection.
But my question is why? I don't understand why we would be limiting future conduct. So we accept that a provisional measure concerns future conduct, but we reject that future conduct can't concern a future interest. Can you give me an example, in other words, of a valid provisional measure in your estimation that would concern future conduct, but not for a future interest?
In the case of Qualiborax versus the Republic of Bulgaria, it was established that where conduct of a respondent state may affect the position of the claimant in the dispute. That is, if the respondent state threatens to do something that will change or interfere with the rights of the claimant in a case. For example, if the respondent will carry out criminal investigations that will disclose things that will actually change the situation of the dispute to the detriment of the claimant, then such future conduct should be limited by provisional measures.
And how would the rights implicated in Qualiborax be any different than here if we're thinking about future rights in Qualiborax versus future economic interests in the immediate dispute?
Okay, I'd like to guide this tribunal to the case of Sitio Oriente versus Ecuador. It was established that provisional measures are extraordinary measures. They should be resorted to as a last resort and not just granted lightly. The claimant's position is that the economic interests of the respondents do not suffice as rights or interests to warrant the grant of provisional measures.
Please proceed, counsel.
Thank you. The claimants have further alleged that the activities The respondent has further alleged that the activities of the claimants threaten the procedural integrity of this tribunal. We would like to submit that in the averments made by the respondent, it can be established that their basis for this claim is speculative. They have not proved that the claimant's activities can in any way interfere with the impartiality of this tribunal. In the averments made in page 38, paragraph 9, the respondent in the 5th line states that the propaganda may affect the impartiality of the members of this tribunal. We'd like to remind this tribunal that the ICSI tribunal in Churchill Mining versus Indonesia established that rights to be protected by provisional measures should not be speculative. In that regard, the rights as so claimed by the respondents are not in threat, and they do not deserve to be granted the provisional measures. As regards the conditions set out by the respondent for the grant of provisional measures, we submit that it was also established in the case of Churchill Mining versus Indonesia that where rights are not so threatened, the condition for urgency and necessity are considered disproved, and therefore the applicant does not receive the provisional measures. However, in the event that this tribunal is convinced that there are valid threats and that the said threats are to be violated if the provisional measures are not granted, we'd like to submit that the condition of urgency and necessity has not been fulfilled in this case. The ICSI tribunal in the case of Quiborax versus Bolivia, and I will request at this point to be excused, Mr. President, to the tribunal, I misquoted the case was Quiborax versus Bolivia and not Bulgaria. Moving on, in the instant, as regards the condition of urgency, the tribunal in Quiborax versus Bolivia established that urgency regards whether the matter cannot await the award or the outcome of the award. The claimant submits that the interests raised by the respondent are matters that can await the outcome of the award. It was also established in Bywater versus...
I apologize for interrupting. I'd like to go back to the position taken by your learned colleague who asserted that we're looking at civil unrest, and I think that they may have even used the word death, linking to the conduct that is being targeted by the provisional measures. I hear you saying here that this can wait, in short. How do you respond directly to their factual assertions?
In addressing the assertions raised by the respondent as regards civil order, shall move to the condition of necessity. The condition of irreparable harm, as raised by the respondent, does not have legal basis, as a matter of fact. This was established by the ICSI tribunal in the case of Gabriel versus Romania, which stated that nothing in law requires necessity or specifically irreparable harm as a condition for provisional measures.
Counsel, I think you may have misunderstood. I'm less interested in applicable legal standards at the moment. I'm more interested in understanding the factual basis supporting the request for provisional measures. We have, coming from counsel opposite, a fairly strong assertion with regard to the need. How do you address that position on the facts, not on the law?
Our position is that the claimant is not responsible for the lack of civil order in the Republic of Tyre. If I could kindly guide the tribunal to page 48, paragraph 1 of the Statement of Uncontested Facts. Line 1 specifically says that the Republic of Tyre is from a civil war in 2012, and that tension still remains between the ethnic communities. In this regard, it is our position that our activities are not the cause for the civil strife in the respondent state.
Just to make sure the tribunal is clear, counsel, your position is that there is no factual nexus whatsoever between your client's conduct and the civil unrest.
Yes. If I could address the matter of necessity, it has been established that in granting provisional measures, what a tribunal needs to consider is the harm that is sought to be spared by the applying party versus the damage that is going to be suffered by the other party. the claimant submits that in considering this interest, what the respondent seeks to do is preserve its economic interest against or to the detriment of the freedom of expression and freedom of the media belonging to the claimants. In this regard, the claimant submits that the interests of the respondent are not sufficient or do not exceed those of the claimant, and therefore this tribunal should not grant the provisional measures. If there are no further questions as regard the first issue, I beg to proceed to the issue of jurisdiction. Thank you. The respondent submits on issue B that this tribunal has jurisdiction to handle this dispute despite the denunciation of the ICSID Convention. The claimant would like to agree with the respondent that Article 71 does provide that a contracting state may denounce the convention by the writing of a denunciation notice. However, we'd like to bring it to this tribunal's attention that Article 72 states that the notice of a contracting state made pursuant to Article 71 shall not affect the rights or obligations under this convention of that state arising out of consent to the jurisdiction of the center given by one of them before such notice was received by the depositary. Our position is that the denunciation of the ICSID Convention came after the respondent had expressed its consent to the submission of disputes to this tribunal. If the tribunal will kindly turn with me to the denunciation notice in page 27.
Counsel, before we do, if you could kindly clarify for purposes of this argument, when does consent crystallize in your submission?
It is our position that the respondent expressed its consent at the moment they signed into the Tyrea Novanda B18 and the Tyrea Kitoa B18.
So, in other words, your position is that the claimant's notice of arbitration has no bearing on consent.
Our position is that the claimants expressed their consent at the moment they accepted the standing offer in Article 9 of the Tyrea Novanda B18 and the Tyrea Kitoa B18. However, as concerns the respondent's consent, which we believe is the matter in issue, such consent was expressed at the moment the respondent signed in the Tyrea Novanda B18 and the Tyrea Kitoa B18.
And what is your legal support for this assertion?
The claimants do not, in the moment, have a legal basis or a case law to establish the exact facts as so stated. Thank you.
Can you perhaps, even if you don't have particular authority to refer to, can you perhaps give us just a logical explanation or a policy explanation supporting your position?
Apart from, thank you, Mr. Arbitrator, apart from Article 72 that protects rights or obligations arising out of consent from unilateral denunciation, we'd like to bring up Article 25, Clause 1, which also states that consent to the submission of disputes may not be withdrawn unilaterally. Thank you. In the event that this tribunal is not convinced on the above arguments, we'd like to further bring it to this tribunal's attention that Article 71 specifies that denunciation shall take effect 6 months after the receipt of the denunciation notice. If the tribunal kindly turn with me to page 3, or specifically page 2 of the request for arbitration. The request for arbitration is dated 29th June 2018. The respondent has asserted that it did denounce the ICSID Convention and has shown to this tribunal that it did so on the 5th of January 2018. However, we submit to this tribunal that such denunciation would have taken effect on or about the 5th of July 2018. Page 3 of the request of arbitration, the tribunal will kindly turn with me. Therein, in paragraph 2, the claimants have asserted their uptaking or the acceptance of the standing offer made by the respondent on the 29th of June 2018. This date being before the 5th of July 2018. In this regard, in making the request before the denunciation took effect, the claimant submit that the consent of the respondent cannot be unilaterally withdrawn, and therefore this tribunal does have the jurisdiction to handle this dispute. If there are no further questions with issue B, I shall ask to proceed to the last issue. The claimant submit that this tribunal does have jurisdiction to handle this dispute despite it being raised on multi-party basis. It has been established that there is no legal provision that requires this tribunal to handle multi-party claims. However, the claimant submit or invoke this tribunal to consider relevant tribunal practice and statistics. It has been established by various tribunals, and also such as in the case of Ambiente Ufosio versus the Republic of Argentine, that most of the multi-party claims submitted to ICSI tribunals are admitted. Statistically speaking, over 40% of the arbitration disputes submitted to ICSI tribunals are multi-party.
What percentage, counsel, of those multi-party disputes that are admitted contain claimants who are advancing their claims based on different bilateral investment treaties?
We do not have the numbers to that exactly, Mr. President.
Counsel, are you able to identify any cases over which a ICSI tribunal has found jurisdiction in which there have been multiple bilateral investment treaties at stake?
I am not able to give one to the tribunal at the moment.
Why should this tribunal break new ground then?
We as the claimants would like to request this tribunal to consider that in considering similar cases that have had multiple parties claiming based on the same illegal measures and the same identical prayers of relief, that this case should be decided, though it is on a multi-party basis.
But why? Perhaps with the benefit of my colleague's earlier question, could you provide us some policy reasoning that would support your argument that we should find in favor of multi-party jurisdiction here?
The respondent has raised the issue of the treaties that are the basis of this dispute, having stated that disputes can only be brought by a national. We'd like to say that if this tribunal agrees that or admits that argument, it shall be narrowing the interpretation of the bilateral investment treaties to the detriment of the claimants. And in doing so, it shall be in violation of the standard set in Article 31 of the Vienna Convention on the interpretation of treaties. Submit that it's in the interest of the rights of the claimants and fair interpretation of law for this tribunal to admit this dispute, regardless of it being on a multi-party basis.
Counsel, I didn't quite follow. What would be in violation of Article 31 of the Vienna Convention?
Okay, Mr. President, may I restate my statement? It will be against the standards set in Article 31 of the Vienna Convention on the interpretation of treaties.
Okay, and what is it that would be inconsistent with the language of Article 31?
Okay, thank you, Mr. President. If the tribunal chooses to dismiss or to admit the argument made by the respondent, it shall be interpreting the bilateral investment treaties and the ICSID Convention in a singular or a over-technical and narrow way. In this way, it shall be against the provisions of the Vienna Convention.
Please proceed.
Thank you. May I ask for an additional minute to conclude on my submission?
Please.
Thank you. It has been established by the ICSID Tribunal in the case of Ambiente Ufusio versus the Republic of Argentine that there are certain conditions for a tribunal to consider before admitting a multi-party claim. The major condition being there should be a necessary link in the claim made by the claimants. This condition was established to have the following requirements. That first, the complaint must arise from the same illegality or from the same rights or obligations. That second, the parties must have a similar factual background as regards the dispute. and the third, they must have identical prayers of relief. On the first condition, I'd like to guide this tribunal to page 4 and 5, and particularly paragraph 12, the problem question. If you could go to the request, you'd find that the claimants, all three of them, have lodged this dispute based on the measures taken by the respondent, specifically the implementation of the TCA ordinances that resulted in the blocking of their websites. They are therefore based on the same illegality. On the second condition of similar factual background, I would guide this tribunal to the provisions of paragraph 7 to 12 in page 4 and 5 of the request for arbitration. If I could brief it up, I'd say that the claimants have lodged this dispute based on the similar facts arising from the respondent's measures. In this way, they have the same factual background. And on the last condition, if the tribunal kindly turn with me to paragraph 18 in page 6, wherefore the claimants have listed their prayers for relief. And among those prayers, you can find they're all the same for the claimants, apart from the issue as raised by the respondent that the exact amount of money required by the claimants are different. We'd like to submit to this tribunal that such a difference was considered in the case of Ambiente Ufusio versus Argentine, where it was stated that it may not be admitted as a sufficient difference because it needs to be examined in the following procedures with the merits of the dispute, therefore cannot be considered when establishing similarity of claims. Thank you.
May I just ask one concluding question? So claimant's position is that the standards of treatment in the respective BITs are identical. Is
Yes.
that correct?
Yes.
Okay.
Any other questions from my colleagues on the tribunal? Then I think that concludes claimant's presentation. Thank you for your time.
Thank you.
And we'll now invite counsel to submit rebuttal and serve rebuttal. I believe that would mean that counsel for respondent would present on rebuttal first.
Members of the tribunal will reserve the right to present as a rebuttal after the proceedings.
May I just invite a reaction from my distinguished colleague on the tribunal to ensure that all is well?
Yeah, if the teams wish to have rebuttal and surrebuttal on all issues at the conclusion of the arguments, then that's fine. Is that correct? Is that what the agreement was?
Yes.
Yes. Team Gilani, is that correct?
That's okay.
Okay, thank you very much. Then I think we can proceed to the merits issues and claimant can start there.
Thank you. My name is Molesi Najoli, counsel for the claimant, as earlier introduced by my co-counsel. I will use 21 minutes to make my submissions and reserve 2 minutes for rebuttals. In the 21 minutes allocated to me, I'll proceed on the following, in the following order. First, I'll submit that the respondent's measures are in violation of the fair and equitable treatment standards laid out in Article 3.1 of the applicable BITs. Second, I will show that the respondent's measures have also unlawfully expropriated the claimant's investments. Third, I'll show that the same measures, as a result of expropriation and violation of the FET standards, the claimants ought to be paid compensation. And lastly, the claimants submits that the respondents ought to pay compensation for costs and legal fees which the claimants will incur in these proceedings. First, I'll make my submissions regard the violation of the fair and equitable treatment standards. The claimant submits that the respondent's measures have violated the fair and equitable treatment standards set out in Article 3.1 of the applicable BITs. The same article states that place an obligation on all contracting parties to accord nationals of any contracting party fair and equitable treatment. If I may refer this tribunal to the case of MTD versus Chile, where in paragraph 149, the arbitral tribunal said the following elements as comprising fair and equitable treatment standards. These are legitimate expectations, proportionality, good faith, due process, and arbitrariness. It is our submission before this tribunal today that the respondent's measures have violated 3 of the stated elements of fair and equitable treatment standards. These are legitimate expectations, proportionality, and non-discrimination. I shall first make my submissions as regards violation of the element of legitimate expectation. Members of the tribunal, what amounts to legitimate expectations? In paragraph 147 of the arbitral award in Thunderbird versus Mexico, the tribunal stated that the concept of legitimate expectation relates to a situation where a party's conduct creates reasonable and justifiable expectations on the part of an investor to act in reliance on the said conduct, such that a failure of the state to comply with the same standard creates or causes the other party to suffer damages. Further, members of the tribunal, I'll refer you to the case of Miculia versus Romania, where in page 29, and more specifically paragraph 3 of the award, the tribunal defines legitimate expectations as follows: as any assurances made by a state to an investor will constitute legitimate expectations. In this case, members of the tribunal, we submit that the state of Terrea made assurances to investors, and which assurances were relied upon by the investor in making the investments, and which later were defied, or the same was frustrated, and thus causing damages to the claimants as a result of the same. If I may refer the tribunal to the statement of facts. In the statement of uncontested facts, page 48, more specifically paragraph 3, members of the tribunal, Mr. Anderson, who is the spokesperson of the Terrean parliaments, states or gives assurances to investors, and the same applies to social media websites, that they will collaborate with them and ensure that there is an environment in Terrea where freedom of speech and freedom of expression are promoted. Further, I also refer you to paragraph 5, and this runs through page 48 and page 49, more specifically line 2, where a representative of the Terrean government further makes assurances to the same effect. Therefore, a situation has been created, or assurances have been made by the Terrean government that any, as regards freedom of expression in Terrea, that any social media websites will be allowed to operate. They will be allowed to make, or the users of the same social media websites will be allowed to respond to messages and actually create an area or a freedom, or create a perception or environment where the freedom of expression is promoted.
Counsel,
however, members of the tribunal,
please forgive the interruption. So that we're all on the same page, I'd invite you to specify what assurances specifically were made by a representative of the Tyrian government, and feel free to quote from the facts as it suits.
Thank you. In responding to that concern, the first is in page 48 and paragraph 3, last line, Mr. Arbitrator, where the representative says that the new media law of Terrea expects to lay down the ground for the advent of such prominent national players and for fruitful collaboration with them in the future. Our submission focuses on the part of fruitful collaboration with them in the future, and this is further buttressed in page 48 and 49, where in line with the same, the players in the social media sector, where these were, the representative says that we declare with absolute certainty that the new internet era has begun and that we will do our absolute best to facilitate the establishment and use of new internet possibilities for the people of Terrea. The legitimate expectation, Mr. Arbitrator, is created where we as the claimants see a scenario where the government of Terrea will allow us as social media websites to operate within the confines of any law, within the confines of any communication, as has been done by the government of Terrea to ensure that there's freedom of expression and freedom of speech in Terrea.
Counsel, were any assurances made to your clients directly?
As regards that question, Mr. Arbitrator, since the Terrean representatives, both in page 48, page 48, and page 49, stated, and it was a public forum where representatives of the social media websites must have been there, and the public at large knew of the same expectations. Our position is that having made the statements at that time, it amounted to us having made the same statements to our social media websites. Therefore, our position is that
we're on the same page. I understand you to be answering no to my question, that no assurances were made directly to your clients. Is that correct?
They were not made directly to the clients, but the assurances made to the public, and which must have assumed to the clients must have assumed to have heard of the same.
If we may turn back to the legal standard that you introduced at the outset, I think that you would look to the Mikula decision in order to introduce the notion of assurances. In that case, were those general public assurances, or were those assurances made to the investor specifically?
Sorry, if I may retract my earlier statement with your permission, Mr. Arbitrator. If I may refer you to the statement of uncontested facts under page 3, the second last line says that more specifically, Mr. Anderson mentioned that the social media network, such as Friends Look PLC, Whistler, and others, are considering Terrea as a new market. Our position is that the same assurances were made directly to our clients.
So you are extrapolating from the fact that they're considering Terrea as a new market to indicate that the Terrean government has somehow made assurances directly to them. Is that correct?
Yes, because a representative of the Terrean government made the same statement, referring directly to social media websites.
Perhaps we can set aside for a moment that particular point and return to the question that I just put to you. In Mikula, with regard to legitimate expectations, were those assurances made to the investor specifically or to the public writ large?
They were made to the investor specifically.
They were, and what were those assurances?
In Mikula, I can't I'll further make my answer to the same, finishing my submissions, if the Mr. Arbitrator will allow me to make the same.
Just one more question on this. Are you aware of any cases involving legitimate expectations in which a tribunal has found in favor of them on the basis exclusively of assurances made just to the public, in other words, not to the investor?
If I may refer the tribunal to the case of MTD versus Chile, the case I referred to, the first case I referred to, in that particular case, the assurances were made to the public, but the investors were mentioned in the same, and therefore it amounted to an assurances being made to the investors directly.
Thank you, counsel.
Thank you. Proceeding on the same aspect, we do submit that the same expectations which I had submitted to earlier were frustrated by the presidential decrees slashing the date for compliance with law number 0808L from 60 days to 45 days. And with this, I'll refer the tribunal to the request for arbitration under page 4, more specifically line 1. Members of the tribunal, we do submit that the same measures undertaken by the respondents were not proportional to the desired aim. If I may refer this tribunal to the case of TechMed versus Mexico, where the tribunal says that any measure must be undertaken that any measure as regards the fair and equitable treatment standards, the state must undertake measures proportionally to their desired aim. In this particular respect, members of the tribunal, as the claimants, we do accept that indeed the peace scenario in Tyrea was not tenable, and the respondents were placed in a position where they had to undertake measures necessary in order to preserve the peace. However, our position is that such measures were not proportional to the desired aim. Members of the tribunal, in TechMed versus Mexico, the tribunal set out a test, which I may refer to as the TechMed test, in assessing whether a measure was proportional to the desired aim. The said test was as follows. There was the public purpose test, there was the necessity test, and another test which the tribunal referred to as a proportionality being the same measure being equal or being proportional to the desired aim and not being excessive. Our position is that by blocking the claimant's social media websites, the measure was not necessary and was a measure which was in excessive of the circumstances met. As regards the necessity test, members of the tribunal, I'll refer you to the Tyrian Penal Code, where under Article 117, it sets out various punishments. One of them is a fine, and then there is a temporal blocking and a permanent blocking. The respondents undertook to permanently block the claimant's social media websites. Our position is that there was a less stricter means of ensuring that the purpose or ensuring that the said legitimate aim was followed. Which measure will the respondents have taken without blocking the social media website, and which were less stricter? We do submit that the respondent might have chosen or may have chosen to individually block the users who are propagating the said messages on their websites and not block entirely, or give a requirement where the social media websites were to individually block the users propagating the said messages and not block the entire social media platform. Members of the tribunal, at this point, I'll pose a question.
Can I interrupt you just for a moment? Can you explain to me how the government would have blocked individual users?
The position was that if the government of Tyrea put out a law or ensured that, or instructed rather, the social media websites to block the said users and not the government themselves, sorry for that statement, so that the social media websites are placed under an obligation to block any user who uses their accounts to propagate ethnic violence or give any messages that will spark ethnic violence in the area. So my point.
Were your clients in a position to do so? Were they willing to do so and technically able to do so? Do you have anything to demonstrate that?
Thank you, Mr. Arbitrator. My clients were indeed in a position to do so and able to do so. If I may point you to the facts, members of the tribunal. My clients were always in a position to abide by any laws which were taken, any laws given by the respondents. And this is why after law number 0808L was given by the respondents, they indeed followed and they did comply with the same law. This is found in the request for arbitration. And also the statement of uncontested facts, members of the tribunal. Under page 51, and more specifically paragraph 16, that the requirements to implement the algorithm, line 3, the claimants immediately set to work on establishing tailored mechanism for combating the spread of hate speech. This demonstrates, Mr. Arbitrator, that our clients were always able and always willing to follow any laws which were given by the respondents. And therefore, we will indeed have followed the same law.
To me, this seems to show your client's willingness to comply, but where do we see your client's ability to comply? That they actually were able to filter out individual users and block individual users.
More specifically, Mr. Arbitrator, we do admit that it shows the willingness to comply. But there is no way in the record of facts where I might point Mr. Bitata to where it shows that we complied, but it shows that if the government had made the law and asked us to comply, we would have complied. But the same statement or the same measure which I'm proposing today before this tribunal was not given by the government, and therefore we can only show our willingness to comply with the same law if indeed it was to be given by the government.
Okay, thank you.
Counsel, if I may just benefit from that Q&A, I have a few follow-ups of my own. To return to a point that you had raised, so it sounds like you're admitting that certain users on these social networks were propagating messages that were leading to violence. Is that correct?
Yeah, there are users who are using the same websites to propagate violence.
And that violence was leading to civil unrest, correct?
Our position is that there were not everyone using the same websites were propagating ethnic violence, but some. But the fact that the same was contributing to ethnic violence cannot be proven from the statement of facts.
My question is not whether all users were, but just confirming that indeed some users were contributing to a more violent situation on the ground. And it seems like all parties are on the same page that that was indeed the case.
Yes.
And I understand you to have just responded to my colleague that your clients were not only willing, but willing and able to introduce measures to filter out those individuals responsible for contributing to that violence. Is that right?
Yes.
So my question to you is, why didn't your clients do that? Why did they need a law in order to prevent that violence from taking place?
My clients actually were under an obligation to ensure that the same social media websites did not propagate the violence, but the spread of social media, the spread of the ethnic violence could not directly be related to the said posts. That is why the government made the said law to comply, to ensure that the spread of messages that were leading to ethnic violence was not put in our websites.
Counsel, I'm not sure I fully follow, so perhaps I can rephrase the question. If we're in agreement that certain users on these social networks were contributing to violence, and if you've just stipulated that your clients were willing and able to filter out these users from contributing to said violence, then why didn't your clients introduce those measures without having the government tell them that they had to?
With the permission of Mr. Bitata, I'll come back to that question later in the interest of time, since my time is running out in this particular instance. We do submit that the said measures were taken in a manner which is discriminatory. In this respect, I'd like to refer the tribunal to the case of Saluka or the Czech Republic, where discrimination was defined as investors engaging in the same business under similar circumstances, but being treated differently. With regard to the statement of facts, under the statement of uncontested facts, rather, under page 22, we find that there were indeed other social media websites in the name of Wing and Truth Seeker, where the same social media or where the same messages sparking ethnic violence were transmitted but were not blocked by the respondents. We therefore ascribe such measures as amounting to discriminatory and thus a violation of the fair and equitable treatment standards. Moving forward, we do submit on our second issue that the respondent has unlawfully expropriated the claimant's investments. By violating the fair and equitable treatment standards, members of the tribunal, the respondents unlawfully expropriated the claimant's investments. Further, implementation of the TCS ordinance and the consequent blocking of the claimant's social media websites also amounted to expropriation. If I may refer the tribunal to the statement of facts, under pages 48 and 49, from paragraph 7 all through to paragraph 9, the claimant has two ways of earning revenue. The same is twofold. One is through the sale of advertising space. The second one is through the promotion of personalized content. These were the only ways which the respondent, the claimants, could earn revenue. Members of the tribunal blocking the same social media websites amounted to a situation where the claimants could no longer gain any benefit from the same investments. If I may refer you to the case of MetaCloud versus Mexico, where in paragraph 10, the tribunal states that measures taken by a state which deprive the investor of the use or benefits of its investments, even if the investor retains ownership or control of the investment, amounts to indirect expropriation. At this point, Mr. Bideta, if I may ask for additional time, additional 2 minutes, if it will be granted, to finish my submissions.
Provided that my colleagues agree to that, but we would have to hold you to a firm 2 minutes.
Okay.
See them nodding. Please continue.
Thank you. Further, members of the tribunal, in the Starrett housing case, the tribunal said that measures taken by a state can deprive or render property rights so useless that they must be deemed to have been expropriated. Members of the tribunal, as stated in the facts under paragraph 7 to paragraph 9 and pages 48 and 49, the claimants still had the physical control of the same assets, but blocking their websites rendered the same investments useless. Therefore, this tribunal must deem that the same was indirectly and unlawfully expropriated. Further, Article 6 of the applicable BATs makes a requirement that states are not allowed or should not unlawfully expropriate the claimant's investments unless the same is for a public purpose, it follows due process, and discriminatory. Having earlier submitted, the respondent's measures are discriminatory and as such are a violation of Article 6 of the BAT. The respondents might argue that they were in exercise of their police powers. Whoever do submit, following the arbitral award in MetaCloud versus Mexico, that any exercise by a state of its police powers must be taken non-discriminatorily, it must follow due process, and the same measure must also be adequate, follow adequate and just compensation. Members of the tribunal, having earlier submitted also, the measures taken by the respondents were clearly discriminatory. There was no evidence of any paid compensation by the respondents. It's therefore any defense, therefore, by the respondents as to whether the same measures amounts to police powers must fail. Members of the tribunal, any unlawful expropriation follows an obligation to compensate. That brings me to the aspect of compensation. Compensation sought by the claimants in Exhibit 7 is not speculative in nature, and the DCF method of calculation should be used by the tribunal to calculate the damages. If I may refer the tribunal to the statement of facts, under page 17, which shows clearly, page 17 of the record of facts, shows clearly that the claimants enjoyed a consistent margin of profit throughout their period of operation inter alia. Further, the DCF method should be used in this instance. The claimants began the operation inter alia for a period of 3 years, or have undertaken the operations for a period of 3 years. In the case of Total SA versus the Argentine Republic, Total SA invested in the Argentine Republic for a period of 3 years. The tribunal stated that Total SA was a going concern and had a track record of profitability. The facts in Total SA and the facts in the present case, members of the tribunal, are similar as to the time period, as to the time period when the investment was in force. We therefore urge this tribunal to use the DCF method of calculation of damages. If I may proceed and make my submission and finalize my submissions rather, members of the tribunal. Lastly, we do submit that the claimants should be paid compensation as to the costs that were used by the claimants, or costs incurred by the claimants in these proceedings. Lastly, my prayers are that this tribunal finds that the respondents are in violation of the FET standards and they are also expropriated the claimants' investments, and that they should pay compensation as a result of the same. And lastly, the respondents ought to pay compensation as a result of the costs incurred by the claimants in these proceedings. Thank you. I rest my case.
Thank you, counsel. Any questions from my colleagues on the tribunal?
No?
Christina, I think that you may be speaking, but I don't know that we can hear you.
Can
There we
you
go.
hear me now? Okay, so I would like to ask a follow-up question about the government's law that was supposed to be adopted to allow you to take measures. I was wondering how you would ensure like compliance. How would you report to the government? Would the government be responsible to ensuring that the users were blocked? Would you submit reports? How exactly would that work so that it doesn't actually create like a burden, cause a burden on the government?
Sorry, if you may rephrase the question, I've not heard it clearly.
Okay.
Yes.
So my question is a follow-up, like when you said that the government could have adopted a law allowing you then, or prescribing that you had to block certain users on your websites. And that would have been a better solution than blocking the whole website. So my question is about ensuring compliance with this law. Like, how would you comply with the law so that the government doesn't have the burden, so that the government doesn't have to check like if the users were actually blocked? Would you submit reports to the government? How would you make sure that this law, like that you are complying and that the government doesn't need to take any additional measures?
Thank you. My position is that in order to ensure the effectiveness, or in order to ensure that after the law is put in place, my clients will ensure that they submit weekly reports of any blocked users' content, and also submit reports of any users, or submit reports basically of the blocked users and ensure that the same is complied with. Therefore, we'll use the process of giving reports to the government as to the compliance of the law.
Thank you.
Unless there are any further questions from my colleagues, I thank counsel for their time and invite counsel to Respondent to provide presentation on the substantive issues in this.
Members of the tribunal, opposing counsel, good afternoon from this side of the world. As earlier introduced, my name is Mioma Reni Cindy, and I shall take 20 minutes to discuss expropriation, fair and equitable treatment, and conclude with the appropriate method for calculation of damages. Beginning with expropriation, the respondents submit that their measures have neither unlawfully nor indirectly expropriated the investments of the claimants. The claimants have failed to show how our measures have caused substantial deprivation or permanent harm on their investments. In Saluka versus Czech Republic, the tribunal found that indirect expropriation is determined by the measures taken by the government causing irreparable harm. With this, I request the tribunal to move with me to page 11 of the statement of facts. It shows claimant's exhibit 4. Now, if we may read together, line 375 shows Friendslook PLC has been blocked pending further notice. Line 395, Whistler has been blocked pending further notice. Line 410, Speak Up Media has been blocked pending further notice.
Counsel, if I may interrupt. So is it your position that in order for a government to be able to avoid a successful claim for expropriation, they can take over a building, but so long as they put a sign up that says this building belongs to the government pending further notice, that doesn't constitute expropriation?
It is our submission as the respondents that the government must have caused substantial harm to the investment. So the measures taken by the government must have a permanent effect on the respondent's investment. That the law has provided that you must have algorithms to filter and block offensive content. However, the respondents The claimants have failed to comply with this law, and the government has taken a temporary action as they wait for the claimants to come into compliance with the domestic laws of the host state. Therefore, it is our submission that as long as the measures of the government are temporary and reversible by an action of the claimant, then these measures do not amount to indirect expropriation.
Counsel, if I may, just to return to my earlier question, is there anything else in the record that indicates that this measure is of a temporary instead of a permanent nature besides the pending further notice language?
Members of the tribunal, I will refer you to Procedural Order number 2 in paragraph 1925 that provides that after their blockage, the claimants had a chance to change the position of the government on this blockage by complying with the relevant law, which they did not. So they provided that 60 days would be feasible for them to comply with the law. However, it is over 1.5 years later and they still have not complied with this law. Remember, the government has only blocked them because of non-compliance. Compliance with the law means their site will be unblocked, of which the claimants have failed to show any good faith to comply with domestic laws in the host state.
Please proceed.
Okay. I refer the tribunal to Belon versus Ghana, where the tribunal only took into account that the measures taken by the government caused permanent cessation of work. We can see here that the Tyrian government only temporarily blocked these sites pursuant to compliance by the claimants. They are able to reverse this action, which they did not as per their own decisions. We are not aware why. So they themselves stopped their investment in Tyria. The actions taken by the government are not permanent and thus do not amount to indirect expropriation. Alternatively, members of the tribunal, the respondents submit that indeed their actions do also amount to lawful exercise of police powers by the state of Tyria. In Philip Morris versus Uruguay, the tribunal took only 3 things into account to determine proper use of lawful police powers: the degree of interference with property rights, the interference with an investment, or the interference of an investment reasonable and objective expectations, and finally, the purpose and the context of the measures taken by the Tyrian government. Now, if we begin with the degree of interference with property rights, the interference relying on my earlier submissions are not permanent. The claimants have a chance to reverse this decision by the Tyrian government, and they have not taken any action to reverse this decision. To come to this tribunal means that the claimants must come to the tribunal with clean hands. A foreign direct investor is required to comply with the domestic laws in the host state. The claimants have shown bad faith by unwilling to comply with the law that is relevant to the current situation in Tyria, and as such, the interference by the government with their property rights is not substantial deprivation or permanent harm to their investment. The second thing is that the purpose and the context.
If I may, just to clarify that point, you seem to be arguing, and please feel free to disabuse me of this, that any time an investor fails to satisfy a domestic legal obligation, they have no basis by which to assert expropriation. Is that right?
We submit that the criteria for determining a foreign investor includes a territorial requirement. And the territorial requirement is such that a foreign direct investor must comply with domestic laws. And where they have not complied with a lawful law passed by the host state, then they are indeed, they have not indeed been expropriated by the government.
Okay, so in other words, you're answering my question in the affirmative, that an investor needs to comply with domestic laws in order to advance a claim for expropriation. That's your position?
Yes.
And that's irrespective of the legitimacy of the law?
Members of the tribunal, we submit that the legitimacy of the law is subject to judicial review, and the ICSID tribunal is not a judicial review court. If the claimants had a problem with the legality of the law itself, they should have approached the courts in Tyria. them having a problem with the way the law has been applied, then material jurisdiction can apply. But with the legality of the law itself, that's a judicial review question that should be taken to the judicial review courts of the Republic of Tyria.
Counsel, what is your legal support for the proposition that an ICSID tribunal may not assess the legitimacy of a host state law?
I will concur with my fellow counsels and get back to you on that.
Thank you. Please proceed.
So the next head of argument is that we must look at the purpose and the context of the governmental measure. Now, we are all aware that radicalists started using the sites to propagate violence in 2016, increasing gradually in 2017, and finally in 2018, we had the outbursts of violence in the relevant states. As such members of the tribunal, we see, pursuant to these activities, the Republic of Tyria passes Law 0808L. And with this, I refer the tribunal to page 51 of the Statement of Uncontested Facts, paragraph 1565, that provides that in the beginning of January 2018, over the course of New Year celebrations in Tyria, ethnic violence resulted in hundreds of casualties. So we can see the context to which the measures have been taken by the Republic of Tyria is in response to the violence erupting in the country. The purpose of this measure has been provided in the wording of Law 0808L, that the government is taking measures to prevent any incitement to violence against another ethnic community in Tyria. When we look at interference with reasonable and investment-backed expectations, which the claimants have claimed as legitimate expectation, the respondents submit that a claim must be objectively reasonable and not based entirely upon the investor's subjective expectations. With this, members of the tribunal, I will refer you to page 48 of the Statement of Facts, paragraph 1480. The claimants have replied on communications only by the Tyrian government. We submit that this is subjective reasons. The claimants must look at the objective reasons in order to invest in Tyria. In order to show that we have legitimately violated their expectations, they must consider the objective reasons. And with this, yes?
We might just clarify, I'm not fully following the distinction that you're creating between subjective and objective with regard to the assurances that were provided to the investors here. Counsel opposite has identified some bases by which to assert that assurances were made. They point, for example, to a statement made by your client with regard to fruitful collaboration. What is your response to that?
Our response to that is that this is subjective in that it is the opinion of someone not intended to be, not directly communicated to the claimants or the claimants' representatives. None of this communication made by the minister in Tyria has been directed to the claimants themselves. And we can see that they regarded Tyria as a strategic market on their own. There is nowhere that any of this communication has been directed to the claimant sites directly. And as such, this subjective opinion by a minister is not something to be taken as a legitimate expectation.
If I may just try to understand that a little bit. Let's say hypothetically that we have an oil minister who issues a press release saying that all oil investments are welcome in our country. None of them will be expropriated. And so oil investors come, and then the oil minister proceeds to expropriate all those investments. Is your position that because that was in a press release to the public and not targeted towards individual investors, that that could not be a legitimate basis by which to assert an FET claim?
It is our submission that a subjective opinion like that must be accompanied by objective interpretations of the situation in that specific country. Therefore, there might be a subjective opinion by a member of the government, but the investors themselves must take into account the objective factors surrounding that country. Does that country really have oil? Do the people in that country fight over that oil? Is oil a point of contention in the country itself? And here, using that same analogy to the Republic of Tyria, we can look at the Statement of Uncontested Facts, paragraph 1. The objective factors surrounding the situation of Tyria is that this is a country emerging from civil war. This is a country transitioning from military dictatorship. This is a country plagued by ethnic tensions. As such, subjective opinions might be taken into consideration. However, they must be accompanied by an objective assessment of the situation in that specific country. As such, members of the tribunal, a claim cannot merely be based on subjective assessments. They must be accompanied by objective assessments, which is to look at the very situation in the country itself. If the very situation in the country itself, which is the objective interpretation of the situation in that country, that is what gives rise to a legitimate expectation. And with this, members of the tribunal, we submit that because there was no substantial deprivation of the investment, because the purpose and the context of the measures taken by the Tyrian government are in reaction to the situation in Tyria, and because we have not violated the claimant's legitimate expectations, our actions amount to use of lawful police powers. And relying on Lauder versus Czech Republic, the tribunal stated that parties to a bilateral treaty are not liable for economic injury that is the consequence of a bona fide regulation within the accepted police powers of that state. If the tribunal has no questions, I'll move to fair and equitable treatment.
I do have a question, although I think it concerns fair and equitable treatment as well. We're surrounding this idea of assurances and the role that they play in creating investor rights. And I think I understand you, but I'd invite you just to confirm. It sounds like what you're saying is that rights can't be based on statements made by government officials, that they need to be based on objective assessments of the reality on the ground. Is that correct?
Yes.
Okay, so that's inconsistent with the jurisprudence cited by counsel opposite. They pointed to the Mikula decision, and they noted there that the tribunal relied on government assurances. In other words, not as you're describing these objective metrics, but by assurances made by government representatives in order to inform an FET claim. And it seems that what you're describing is not consistent with that. So are you saying that we shouldn't be looking to that jurisprudence?
Regarding the very same jurisprudence, in Metaclad, the information was made to the investors. In this situation, there was no information made to any specific investor by the Republic of Tyria. That is the difference between these two situations. There was a direct communication that come and invest. Here, there is no direct communication by the government of Tyria to any particular investor. As such, you cannot rely on a general assurance to the public to come and invest. It was not an address to investors, but an address to the people of Tyria specifically. So them to rely on this subjective factor alone to create a legitimate expectation is in fact contrary to that jurisprudence, because in that case, the communication was to the aggrieved parties.
Thank you, counsel. Please proceed.
Yes. Regarding fair and equitable treatment, the respective BITs raise an autonomous treaty standard. In Article 3 of these BITs, it has been provided that in order to violate the fair and equitable treatment standard, an action must either be unreasonable or discriminatory. The claimants have asserted that our actions are indeed discriminatory. However, I request the tribunal to turn with me to page 8 of the Statement of Facts. Page 8 of the Statement of Facts, paragraph 1 of Article 51 bis. It provides that every social network shall develop and implement an effective algorithm suitable for its scale of operations. including but not limited to the audience size and the amount of content published. With this, the claimants have stated that we have favored Winks and Toothseeker, but I request the tribunal to move with me instead to paragraph 1630 on page 54 of the statement of facts, actually page 53, sorry, of the statement of facts, paragraph 1630 and 1635. We see that taking into account what the law has said, Winks was not blocked because its filter was only inefficient to such that it couldn't reach spam messages. And taking into account the audience size of Winks and its content, this was not a measure, an inconsistency large enough to subject it to being blocked. Let's look at Toothseeker. It has been, in the statement of facts, remained silent about why Toothseeker was blocked. But looking at the wording of Law 0808L, a threshold was set out by the government of Tyria regarding audience size and content published. Looking at paragraph 1635, we see that Toothseeker has nearly 5 times less than FriendsLook's users. FriendsLook is the most famously used site in Tyria and most parts of the world. Seeing as this threshold of tolerance was not met because Toothseeker does not have enough or many viewers, that is why it was not blocked. We must look at the wording of the law, which has provided us with the important threshold that was being considered by the government of Tyria. As such, seeing as the government of Tyria was acting in accordance with the law itself, it was not invoking any discriminatory measures against the claimants. If we look at the reasonableness of this measure, we see that regarding the context on which these measures were taken, there is violence in Tyria. Remember, on 1st January, New Year's Eve was celebrated by hundreds of people who ended up in the hospital because of violence erupting in the country. 12 days later, we have Law 0808L that only comes to make sites filter their content in order to avoid insightful messages by radicalists on social media. Seeing as my time is almost up, I request for 3 additional minutes from the members of the tribunal.
I defer to my colleague who is keeping closer watch of time than I am.
I would encourage counsel to wrap it up in 1.5 minutes or so. We're running a bit behind.
So seeing as these measures were not unreasonable or discriminatory, the respondents have not violated the fair and equitable treatment standard established in the various BITs. If we look at the legitimate expectation under fair and equitable treatment, we see that subjective measures, relying on my earlier submission, subjective measures should not be the only things taken into consideration. And considering that this communication was not made directly to the investors, but was made to the public, then it did not give rise to a legitimate expectation as claimed by the claimants. Moving on to the appropriate method for calculation of damages, the respondents submit that the claimants have failed to produce any evidence to support their damages claim. So just in case the tribunal were to find that the respondents were liable, the DCF method is not appropriate to calculate damages in this situation. First, because they have not produced any documents to show their prospective business plans. They have claimed they were planning to expand. Where are the business plans to show evidence of this expansion? 2, the DCF method requires sufficient data in order to be able to calculate future cash flows. 2 years is not enough to provide sufficient data for the DCF method. Thirdly, the weighted cost of capital being put at 5% does not depict the situation in a country that is coming from civil war, coming from military dictatorship, and plagued with ethnic tensions. And finally, the calculation of interest has not been shown. How did they arrive to this amount in the calculation of interest? Where is the proof of that? Without any such proof, we cannot rely on their figures calculated by the DCF method. This is why the respondent submits that proven expenditure is the best method to calculate damages. What the claimants have actually lost direct damages. And with this, the respondent submits that we request the tribunal to find that we have not indirectly expropriated the investments of the claimants. We have not violated the fair and equitable standard of treatment. And finally, proven expenditure is the appropriate method to calculate damages. With this, the respondents rest their case. Thank you.
I'd like to invite my colleagues to put any additional questions to counsel.
I don't have any questions at this point.
Questions either?
Very good. The tribunal thanks counsel respondent for their time and invites counsel to both parties to provide rebuttal and surrebuttal. Have counsel between the parties ascertained who will speak first on rebuttal and surrebuttal? That's a question directed to counsel from both parties. Do we know who is speaking first?
Thank you, Mr. Arbitrator. I believe it's the counsel for the claimants that's going to rebut on the first issues first, then I'll rebut.
Counsel for respondent, is that consistent with your understanding?
No, our understanding was that they rebut everything and then we rebut.
I will defer to my colleague who may be more experienced with consolidated rebuttals than I. Chris, any guidance on this?
For the sake of convenience, let's have the respondent do rebuttal on issues A to C, followed by claimant's surrebuttal on those three issues, then claimant's rebuttal on issues D and E, followed by respondent's surrebuttal on those issues.
And how much time have we allocated for these rebuttals and surrebuttals?
We have a total of 5 minutes each. I would ask claimants to stay well within that, and respondents to stay well within that.
Very good. Then to echo that to the parties, I will also keep time and as needed exercise my prerogative to interrupt and conclude submissions should that prove necessary. Let's please proceed.
Thank you, members of the tribunal. Firstly, I'd like the tribunal to move with me to page 3 of the statement of facts. Page 3 of the statement of facts, under paragraph 2, provides, this is the request for arbitration submitted by the claimant. It provides that by submitting this request for arbitration, the claimants accept the standing offer made by Tyria to arbitrate the investment issues. We submit that the claimants have admitted that what is contained in the BIT is an offer to arbitrate. We look at when this request for arbitration was made. It was made on 29th June. Remember, the denunciation of the AGSIC Convention happened on 5th January 2018. As such, Article 72 of the AGSIC Convention provides that the obligations that will be protected by the conventions are those that arose before the notice of denunciation. Looking at the request for arbitration, the claimants themselves admit that they accepted the offer after notice of denunciation. Therefore, this is not an obligation that is owed by them from the respondents. As such, members of the tribunal, I'd like to move forward to the provisional measures. And with that, I refer the tribunal to page 53 of the statement of uncontested facts. Here it has been provided that the claimants engaged a public relation firm and resorted to other unofficial measures, some of which confirmed by evidence. So which means the claimants were indeed persecuting us in the media. And remember, pursuant to procedural order number 2, the disputes have reduced in urban areas. So violence in Tyria has reduced in urban areas, whereas in rural areas, the violence has remained the same. People are still fighting. And remember, in rural areas, people are using newspapers and the television. That is what they're looking at. And that is where the claimants are attacking us from. And remember, the major warring parties in Tyria are Minyar and Tatia. Considering that the president of Tyria is from the Minyar community, we can see they are incited to fight us when they see the claimants making such assertions like, we do not believe in the freedom of expression, we do not believe in that people have rights to talk about their issues on social media. When they make those comments and people see these things, they are directly affecting the situation in Tyria, and thus provisional measures should be granted because it is directly attributable to their actions, which brings forth the point of urgency that as long as they continue making the statements, the situation in rural areas will not change.
Madam Counsel, may I interrupt you briefly? Because if you wish to, you or your co-counsel wish to have rebuttal on the other points or rebuttal on the other points, you're going to need to wrap up now.
With that, we have wrapped up on the first three issues.
Thank you.
So before we continue, just for purposes of timekeeping, I've recorded 2:52. That's omitting the point raised by Chris, which leaves us just over 2 minutes for respondents' rebuttal on the merits. We'd like to now invite counsel to Claimant for a rebuttal on the preliminary issues.
Thank you, Mr. President, for this opportunity. I shall respond to the submissions of the opposing counsel. The Respondent's counsel has mentioned that what we accepted in the request for arbitration was a standing offer. However, I'd like to submit that the matter in question is not when the claimants made or gave their consent, but when the respondent gave their consent, as is required by Article 72 of the Exit Convention. Article 9, specifically Clause 3 of the Tyria Novanda BIT, and similarly the Tyria Kitoa BIT, provides that, and I shall read, each contracting party hereby gives its unconditional consent to the submission of disputes as referred to in paragraph 1 of this article to international arbitration in accordance with the provisions of this article. Further submit to this tribunal that the respondent state is a contracting party as provided for in clause 3 of article 9, and therefore its consent was given in ratifying the BITs. Further submit that as provided for in article 71, denunciation takes effect 6 months after receipt of notice. The respondents have submitted that at the time we made the request for arbitration, the denunciation was effective. However, 6 months from the date of notice of denunciation should be on or about the 5th of July. The request for arbitration was made on the 29th of June before the 6-month period had expired. In that regard, therefore, the denunciation was not in effect. Thank you.
Thank you, counsel, very much for that. I have about 1:30. I'd like to now invite, beg your pardon?
Excuse me, I'd like to reserve the half a minute for my co-counsel, if that's okay.
As you wish. If your co-counsel could please proceed with regard to rebuttal on the merits.
Okay, thank you, Mr. President. The respondents averred and used the case of Billon versus Ghana in stating that in indirect expropriation, it must be shown, or one of the requirements stated that the same was indirect expropriation. However, we do submit for this tribunal that following the same case of Billon versus Ghana, it was shown that it should have been possible for claimants to comply with the said laws for the same requirements to be met. However, in this particular instance, it was not possible for the claimants to comply with the said laws. Law number 0808L, requiring claimants to put out or to have an effective algorithm. In that particular instance, we made efforts to comply with the same, but before the same was done, the respondents had already blocked the claimant's social media website. We therefore do refer to the same case and say that it was not possible for us to comply with the same law in regard to the same. As regards the aspect of damages, the respondent stated that the expert report, or said that the expert report lacked market expansion evidence. However, I'd like to refer this tribunal to Claimant's Exhibit 7, Claimant's Exhibit 1, rather, starting from page 7, members of the tribunal. If you may move with me to page number, the same article under page number 15 for the first requirement. Not page 15, page number 18 rather. Under paragraph 550, opportunity for market expansion and lost profits. That is the subheading under the same requirement. And it can be seen clearly that there is clear evidence of opportunity for market expansion. There is under legal and administrative, we have French Look, Whistler, and Speak Up. Therefore, the respondents averring that the same evidence lacks is the wrong position taken by the respondents. Additionally, members of the tribunal, I'll refer you to the same Exhibit 1 under page 15. More specifically, paragraph 520, the respondents stated that the evidence adduced by the claimants in this respect lacks legal basis. However, according to that, it's an averment by the expert witness, and he says, and I quote, "I am an expert witness and not a witness of fact, and any evidence or any information stated herein has been given as a result of information adduced to him to the same effect." Therefore, it's our submission that the same evidence has legal basis and should be admitted before this court. As regards the DCF method of calculation of damages, members of the tribunal, the respondents stated that this tribunal should not adopt the DCF method. It is, however, our submission that it is the most appropriate method to be taken by this tribunal in calculating damages. Why? Because looking at Claimant's Exhibit 1, a comprehensive reading of Claimant's Exhibit 1 shows clearly that the claimants were indeed or in a period or had the investments in Terrea for such a period that could amount to be termed as a going concern. There was therefore a track record of profitability. And I may refer this tribunal to the case of Lone Miculia, where the tribunal averred that in order to use the DCF.
Can I interrupt you for a moment? I think we're also running into an issue of equal time with the amount of time that was given to the respondent. So you please wrap up.
Okay, I may wrap up by submission that state that the DCF is the appropriate method for this tribunal to use to adduce the evidence or to calculate the damages before it. Thank you.
Submission. Thank you, counsel. Now to invite respondents' counsel on rebuttal to respond to those issues. The rebuttal not to exceed 2 minutes and 8 seconds of length.
Thank you, President of the tribunal. It is the respondent's submission that the claimants are misleading this tribunal. They have claimed that we blocked them before the passing of Law 0808L. However, I request the tribunal to move with me to page 51 of the Statement of Uncontested Facts. Let's follow the timeline provided. We see Law 0808L passed on 12th January 2018. We see the respondents being blocked on 28th, pass on to page 52, 28th February, 1st March and 2nd March 2018. This is specifically after 45 days as stated in the specific law. Therefore, the claimant's suggestion that we blocked the sites before the law came into existence is a misleading of this tribunal. We also submit that pursuant to the expert opinion submitted by the claimants, they have provided for opportunity for market expansion and lost profits. Where is the business plan that shows this is their legal administrative fees? These are the receipts for their legal administrative fees. This is what they use to advertise. Where is the receipts that shows this amount? Therefore, are we to assume that they pulled these amounts from mid-air and expect us to pay them these unreachable amounts? And if we look at interest, members of the tribunal, there has been no no percentage is given for how they calculated this interest. How did they end up at this conclusion? They want us to pay 69.08 million for Friends Look alone, and they haven't shown us how the interest comes into play. If we look at the data provided for calculation of future profits, 2 years, in 2 years, their profit was supposed to triple, and in some instances, quadruple. It's not supported by the facts in the case. How was 14 million to turn into 52 million with 2 years of operation? The DCF method is thus not appropriate to calculate damages in this question. And to respond to the question that the president of the tribunal asked me before I conclude.
Counsel, you have 10 seconds.
Okay, thank you. Article 25 of the Hague Convention states that a tribunal shall deal with legal disputes arising out of an investment and not on the legality of the laws passed.
Thank you, counsel. I'm afraid you're out of time. We're going to have to conclude there. Thanks very much to counsel for both sides for their presentations. This was very helpful. Any additional questions or concerns, points from my colleagues before we conclude these proceedings?
Nothing for counsel. Do my colleagues want to confer on the scoring separately? I don't know how pressing other things are for you right now.
May I propose that we do so, but in 5 minutes?
Yeah, that's fine. Could I ask, the tribunal would then recess now for, I think about 15 minutes would be enough time for us to confer, probably. If we get together in 5 minutes and have a decision in 15 or maybe 20 minutes. So we can all return here in 20 minutes. Okay?
Chris, just to confirm, does that mean that we as members of the tribunal should stay on and invite our colleagues as counsel to log off?
If counsel leave, then we can stay on and confer privately. That might be the most efficient. Is that okay? So counsel teams Jelani and Chagla, if you can rejoin us in 20 minutes here, I'm going to remove you from the hearing until then, okay?
That's okay.
Thank you.
Thank you.
Okay.
Chris, just before I break, just as a heads up, I have a hard stop at noon Eastern, which is in 30 minutes time, which will give us 10 minutes for feedback.
Do you want a 5-minute break just generally, or do you want to just go through marks now and then?
I would just appreciate a moment to step out of my office for a second, and then
that would be good for me too, because I need 5 minutes too.
Okay, very good.
Okay, thank you. All